Good morning, and may it please the Court. Lucas Vebber for the Plaintiff Respondent Cross Appellant Ken Brown. In addition to the standing question that was raised by some of the appellants here, there are 5 issues on the merits pending before the Court, 2 in the appeal and 3 in the cross appeal. All 5 issues stem from the same facts regarding the clerk of the City of Racine's administration of in-person absentee voting during the August 2022 primary election.
So if we would agree with you on one of those 5, would we have to decide all 5?
No, Your Honor, I don't think you would. You could reverse WEC's decision on just one of those 5. We would ask that the Court still address all 5. We think they're important issues that would still be worthy of the Court's attention. The first 2 issues deal with the location of the sites that were selected for in-person absentee voting. The statutes require that those sites be as near as practicable to the office of the municipal clerk and that they afford no advantage to a political party.
Counsel, if we would decide that there is no standing, then some may suggest that, okay, then that's it, no standing. Let's say we go further. And address some, but not all, of these 2 on appeal and 3 cross appeal. Rank them in the order of priority that you want us to address.
Yeah, Your Honor, I think first would be the use of the mobile election unit. Second would be the nearness requirement, the as near as practicable. And then closely related to that is the political party advantage requirement. And then the remaining 2 issues, which are whether the sites remained in effect until at least the day after the election, and then whether or not the clerk's continued use of the City Hall as a location violated the requirement that when an alternate site is used, no functions related to absentee voting continue to occur in the clerk's office.
Thank you.
But I would concede that if we don't have standing, that itself would be fatal to me today. So
I want to ask you a question about standing, perhaps more than one. My understanding from the record is that your client, Mr. Brown, witnessed early in-person absentee voting at 2 places. One was the clerk's office, and the second was a van when it was parked at the Regency Mall location.
Yes, Your Honor.
And those, your client saw both those on the same day. I'm having a hard time understanding how your client was injured in fact by witnessing. It seems he might be one step removed from
Your Honor, so 5.061 allows Brown, who is an elector, to file a complaint because he believed that his election official was acting contrary to the law. That's what 5.061 allows for. No party has contested that Brown didn't have the ability to file that complaint, or that I should say they never suggested that he improperly filed that complaint with WEC. So the only question then is whether he was able to appeal WEC's dismissal of that complaint. Under 5.06 sub 8, as has been discussed, any complainant who is aggrieved by an order issued under sub 6, here it was WEC's dismissal order, may appeal the decision of the Commission to the Circuit Court. This case was very recently resolved by this issue was very recently resolved by a published opinion of the Court of Appeals in Hess versus WEC. In that case, WEC argued, as they do here, that the complainant who filed the complaint there lacked standing to appeal when their complaint was dismissed because they were not aggrieved. The Court of Appeals decided the issue very simply. They rejected the argument, and they held that the statute plainly states where a complainant, quote, having filed a verified complaint with WEC, as Brown did here, and having received an unfavorable decision from WEC, clearly meets the qualifications of the statute as a complainant aggrieved by WEC's decision.
I want to make sure, I want to summarize what I'm hearing you saying, and I'm sure you'll correct me if I'm wrong. So is it your position that any time a party files a complaint with the Wisconsin Elections Commission and then loses, that party under 5.06 has the right to appeal to a court just by losing, that makes them aggrieved?
Yes, Your Honor. I think that's what 5.06 sub 8 contends, yeah.
no matter what.
No matter what,
I'm just thinking about, there was a hypothetical, and this is on page 21 of WEC's reply or response brief. It came to us as a third brief. There were a lot of briefs here. You don't have to, I'll tell you what it is. Okay. It says, it imagines a voter who mistakenly believes that state law requires elections officials to throw away all ballots that includes votes for a particular party. So it's taking this to perhaps an extreme example, yes? Sure. While the belief is patently inaccurate, there's no doubt that the belief would allow the voter to file a complaint under 5.06 sub 1. So under your view, even in this, I would agree it's an extreme example. Even there, if that person lost in front of the Wisconsin Elections Commission, they would be aggrieved and they could file their lawsuit in circuit court.
Yes, Your Honor, I do believe they would. I think the special proceeding that's created by sub 8 to review WEC's decisions would allow for that. I think there are other things that would come into play there. I mean, frivolous lawsuits get filed all the time and would be subject to, other penalties, I suppose, and ethics rules there. So if frivolous complaints were being filed and frivolous complaints were being brought in circuit court, presumably there'd be other remedies. Presuming, of course, that this would be a frivolous argument they're making on the extreme. So, but I do think that Section 8 would allow any party. It simply says the aggrieved party, and I think in that context, it just means whichever party loses before WEC. And that's what the Court of Appeals said in Hess. I'm sorry.
So there's 1,852 clerks in municipalities overseen by 72 elected county clerks. So under your theory, any voter, anytime, based on their belief, which could include just standing there watching someone vote, make whatever their belief is about what happened, they can not only bring it to WEC, but they can bring it to the court, and it then is subject to the court process. Any voter, there's no guardrails at all on what you're proposing, correct?
Your Honor, I think Section 5.06 sub 1, which creates the ability to file with WEC, is kind of the first filter, but I think that confers very broad ability on any elector to file the complaint.
Right, but it says nothing about appealing it other than using a word aggrieved, which under your reading, you really don't need the word aggrieved. You basically just can appeal it. It doesn't, aggrieved has no meaning in the version that you're telling us.
Yeah, and I think that's consistent with what the Court of Appeals found in the Hess case.
I understand that has happened since this case was filed, but that's what you're advocating to us, that we read out the word aggrieved, that we allow this statute to stand for the proposition that any voter, anytime, not only has the right to take this to WEC, something they believe, that they can then take that case if they lose and file a lawsuit.
Yes, Your Honor, and I think this is evidenced that reading of the statute is evidenced by what would happen if an election official were to lose. WEC would have determined that they violated the law. They certainly couldn't claim they were aggrieved because they violated the law, and they would then not be able to bring a complaint under the statute, right? Because where would their aggrievement come from in that case?
That's confusing because you're saying they would bring something to under 5.06 sub 1, any voter, and I get that that's what 5.06 sub 1 says, any voter it's a low bar, it's what you believe, right? Where else do we have that kind of low bar other than in an election statute, which makes sense with WEC, but you're then taking it that next step, which takes out any kind of personal injury to the person.
Your Honor, I think that's the policy choice that the legislature made here when they created this proceeding to review WEC's decisions, and our task today is simply to give that meaning. I think Brown clearly has standing to bring this complaint under Hess, and because he has been aggrieved, because his complaint was dismissed.
So why do we have the WEC layer at all? Why doesn't the person filing the complaint go straight to the circuit court?
Because I think it gets to some of the other issues, and I think perhaps that's where WEC is confusing standing to bring a general declaratory judgment action in circuit court, which is not what we've done here. We brought a special administrative appeal of WEC's decision. WEC does the fact-finding. The record is the record produced by WEC. And then it goes to the circuit court, which reviews the legal argument. That's what 5.06 requires on appeal.
But just to clarify, I think your position is that under 5.06 sub 1, that it's not any elector anywhere can challenge any action of any election official. It's an elector of a jurisdiction can challenge the actions of election officials in their jurisdiction, right? So it's really voter specific and local election officials that are being talked about here.
Yes, Your Honor, that's an important distinction, and thank you.
And your standing, are you done?
Yeah.
Your standing argument is just based on 5.06, which is to say, I don't hear you adopting the language from Teagan, which talked about the pollution theory of standing, which said basically that where an elector would have standing to challenge certain election procedures that they believed would, quote unquote, pollute the integrity of the result. I don't hear you adopting that, but I just want to make sure that I'm clear.
Yeah, Your Honor, correct. We have not at any point in this litigation argued for vote dilution or claimed that we have standing because of that.
And you also, I am going to guess, maybe I shouldn't, Justice Ann Walsh Bradley asked questions about 227 standing, and I'm wondering if you are looking at all at Friends of Black River Forest and adopting any of the standing analysis from the framework that was set forth in that case.
Correct, Your Honor. As Justice Bradley had explained earlier, we don't believe that Chapter 227 and Chapter 506 are the same. We don't believe that the standing analysis under Chapter 227 applies to 5.06. I will say that the Court of Appeals in Hess did apply Friends of Black River Falls to the 5.06 challenge there, and that's when they determined that it had standing. But, you know, I think there are many reasons that the statutes differentiate between each other. 5.069 only incorporates the standards of review for agencies under 227.57. 227.03 sub 6 says specifically that orders of the Election Commission under Section 5.066 are not subject to this chapter. I think there are a variety of textual reasons that indicate they were intended to be separate. And of course, the term person aggrieved, which is used under Chapter 227, is not the same as a complainant who is aggrieved under 5.06. That is a term of art that is specifically defined in Chapter 227, and it does not apply to 5.06.
So, counsel, this election was in 2022, correct?
Yes, Your Honor.
It was a primary election, right?
Yes, Your Honor.
So how would partisan advantage be impacted in a primary?
Well, votes still occur. People still get out to vote. If it makes it easier for members of one party to go vote in the primary versus members in another party to go vote in the primary, that political party is still benefited because their voters had an easier time voting. Which gets me to the first two merits issues under Section 5.06's requirement that those locations, the sites, be as near as practicable to the municipal clerk's office and that they afford no advantage to a political party.
I just want to go back. I've got one more question about this primary election. I didn't see anywhere in the briefs that you allege that Mr. Brown actually voted in that election. Is that correct?
I don't know if the record reflects that, actually, Your Honor.
Okay.
Counsel, as you try to segue, I'm going to stop you.
Yeah. Thank you. To understand,
No, I am going to stop.
Give me, Your Honor. I apologize.
Oh, you have an impossible job. I'm sorry.
Two things. Number one, boy, I thought this all boiled down to, not all, but it boiled down to the standing issue, how you define aggrieved in sub 8. But after the exchange with you and Justice Dallett, it sounds like the word aggrieved may be almost superfluous, because why would anyone appeal? You know, it's not a useless exercise. They appeal because they don't agree with something. So maybe what I thought was the essence of the standing argument, how do you define aggrieved, falls by the wayside. That's my first question. I do have a second question, but let's start with that. Does aggrieved, is that a meaningless word? Is it surplusage here? Because why else would you appeal?
Yeah, Your Honor, and I apologize if I created some confusion with how I explained it. Aggrieved does have meaning. Aggrieved means it's the party who loses before whack. I mean, it recognizes the longstanding principle in the law that the party who wins doesn't get to appeal. And that's how we explained it in the briefing. And I think
yes, that's exactly the way you explained it. And I just saw a little erosion of that. Now, I may agree or disagree with your definition of aggrieved, but let's say I disagree. And, but I want to get to some of these other issues. What's the analysis of saying no standing, but nevertheless, we're addressing questions? What's the hook to be doing that?
Your Honor, I think you were asking if the court were to find that we don't have standing to bring these claims, can the court still proceed and resolve any of these issues?
Yes, that's a better statement of my question. Thank you.
I don't know if you could, but if you're willing to, I'd be, I think it would be beneficial to the voters of Wisconsin and to the government entities to resolve these issues, certainly. But I think if the court were to determine that we don't have standing to be here today, I don't think our claims could be heard.
You don't think so? I was looking at a case, so much fun, well, sort of not so much, State versus Schumacher, and former Chief Justice Heffernan wrote it. And he has a very robust view of the court's power for the scope of judicial review. And he speaks in that case about, you know, even if we don't have standing, he makes reference to that we can still advance the case and address issues of great public interest. He said, we can reach issues, for instance, that are moot, but nevertheless of great public importance. We've said we will reach issues of great public importance even when the parties would not ordinarily have standing to raise the issue. Yes, no?
Yeah, Your Honor, we didn't brief that question at all before the court, but again, I think if the court is still willing to reach these issues, I think it certainly should.
One more quick question on standing. What do we do with all of our cases that require at least a trifling interest?
The interest is here, Your Honor. I mean, the interest is granted under 5.06.
So you find the interest in the statute itself, just the mere fact that the statute exists? You don't think there also needs to be some kind of injury in fact? Your
Honor, I think the 5.06 creates this process, the complaint process before WEC. It gives WEC the ability to hear these complaints, to do fact-finding, to issue orders to resolve the complaints, and then it creates an appeals process to create this special proceeding that you can then get to before a judge to review the decision of the state agency. I think that process itself confers standing, and you are injured, any party is injured in fact, when their complaint is dismissed and they can't get relief under that process before WEC. If WEC wrongly dismisses their complaint or misinterprets a statute and then dismisses a complaint, as Brown has alleged here occurred, then his only recourse is to go to circuit court and have that reversed. I'll move on to the as near as practicable language. I think the requirement in statute is best understood in the context in which it was created. Up until the late 90s, Wisconsin law required a reason to vote absentee. In 1999, the legislature amended the law to go to no-fault absentee voting. You could vote for essentially any reason. As a result of that, there was an influx in voting via absentee, and it became interested in allowing a site outside of the municipal clerk's office to vote at, an alternate in-person absentee voting site. When the legislature then created 6.855, which allowed absentee voting to occur at these alternate sites, it included the restrictions that the sites be as near as practicable to the municipal clerk's office and that they not afford an advantage to any political party. And the reason for doing so is obvious. They were concerned that when a site was moved out of the traditional neutrality of the clerk's office, that partisan games would be played and that the location...
Can I ask, is your argument that having an alternative voting site anywhere outside the ward of where the clerk's office is would violate the statute unless there's some other ward that under some sort of analysis has the same type of partisan breakdown? Is that where you land?
Your Honor, I think I think you could have one outside as long as it was as near as practical and did not afford an advantage to a political party, which is a nuanced answer, I understand, but I think what the ward analysis does is it makes it easy on clerks, right? You're required to not afford an advantage to a political party. That necessarily requires some sort of look at the political makeup of the location where the site is going to be. There's no other way to read that provision of the statute.
I understand I'm conflating two of your issues. I appreciate you going along with that. I want to ask you a couple questions about the ward. So there isn't anything in 6.885 that talks about assessing ward level voting behavior, right?
There is not.
And,
correct.
And it doesn't say, there's nothing in that statute also that says the clerk's office is supposed to be the benchmark for any alternative voting sites. I understand that the ward data is available, and perhaps that's why you relied on it, but it seems like really imprecise to me for a number of reasons. Wards can change, and they do change, and the wards in Racine have changed between the time of the data that you have, which I believe is just before 2000, and they changed after 2022, which again it went from 36, I believe, to 49-ish. I think from 36 to 49 wards in that time. Wards move,
yes.
I guess what I'm saying. The timing doesn't seem right here. And the third thing I'll throw out, and I know Justice Portisay was asked this, is it is hard for me to wrap my head around this it was a nonpartisan election. I'm sorry, it was a partisan primary, so partisanship did not matter. For all those reasons, I have a real hard time with the arguments around your ward analyses.
Yeah, and thank you, Your Honor, for the question. I think it gets again to why that provision was put in there in the first instance, right? It was the legislature's concern that an in-person absentee ballot site located outside of the municipal clerk's office would afford or would be used to play games, placed in a location that made it easy for members of one political party to vote, members of other political parties more difficult to vote, right? That's the obvious concern and why it was added into the statute, just from the plain language of the statute itself. But the only way then to resolve that concern, or to give that concern any meaning in that text in the statute, is to look at the partisan makeup, the political makeup of the site where the in-person absentee voting site would be located. And the only way to do that at the local level is to look at ward data. That's the only way votes are broken down.
Don't you end up disadvantaging certain people? And I'm thinking about, there's, on page 22 of Block's brief, they talk about the city of Milwaukee. So I'm worried that we're disadvantaging certain voters, right? Voters who have a hard time getting to the polls, who have to work late. I mean, according to Block, the city of Milwaukee, and I'm on page 22 if you're trying to flip to it. The city of Milwaukee in the 2022 general election voted for governor. The ward in which Milwaukee's Board of Election Commissioners is located, which is Ward 1414, they saw 394 votes cast for Democratic candidate Tony Evers and 294 cast for Republican candidate Tim Michaels. And then they asked how many of Milwaukee's 354 wards had that same partisan makeup, and it's 0. So I think under the analysis that you're putting forward, only Ward 141 could hold an alternative site, which would mean everyone else in Milwaukee would only be able to access alternate voting if they went to Ward 141, which kind of throws out the whole idea of having easy early voting and making voting accessible for many, many people.
A couple of responses to that, Your Honor. First, the City of Milwaukee data was not part of what WEC considered when they heard this case. It's not officially part of the record.
Yeah, and I'm
just
like as a just as
Understood.
an example. I don't even know if these numbers are right. It almost doesn't matter.
The data that is in the record on Racine provides similar results. There
Okay.
are no wards with identical makeup, but
Fair enough.
I think that gets to a little bit into the one Wisconsin arguments that were being made earlier. There was the quote, the quote that was given: the opportunity to participate may decrease as distance increases, but the quote was incomplete. He cut off the next line of, yet Milwaukee Clerk's office is centrally located. So the Seventh Circuit gave some indication that they actually didn't think that it would have been there, and I don't know, what the analysis would have been because the issue was moot, but in analyzing those particular challenges certainly casts some serious doubt on the one Wisconsin opinion. Now, I think what the legislature was trying to do was say that, hey, the default voting location is always the clerk's office. I think everybody agrees with that. That's what the statute says. When you move it out of the clerk's office and go somewhere else, that somewhere else has to be as near as practicable to the clerk's office, and it cannot afford an advantage to a political party. So the easiest way to do that is, of course, to keep it in the same ward. If it's in the same ward, it would not confer any political advantage or any advantage to a political party, and it would always be as near as practicable.
Okay, and let me push back on that a little bit. You've made an assumption that somehow it benefits the political party of the people that make up the ward in the most numbers by putting an alternate site there. But isn't it true that people work in other wards? They run errands in other wards. They pass a ward on the way to work.
Yes, sir.
Democrats and Republicans. And so how can you just make this presumption that having another site in their ward is somehow going to benefit anybody? It could hurt Republicans. It could hurt Democrats. It doesn't make sense to me what you're saying, that you have to all lump them into the one ward where the clerk's office is. That doesn't seem to correlate in any meaningful way with giving access based on some kind of political party is advantaged or disadvantaged. I just don't understand that connection.
Your Honor, I think it's, first of all, it's immaterial if they could go vote anywhere. The question is, does the site location make it easier for voters of one party or another to vote for,
And
right?
does it
So
make it easier to have them all in one place? If you work in another ward, you are passing another ward on your way, you're on the border of two wards, how does it make it easier just by sticking another one there?
If the clerk had said, for example, that every ward that has 99% Democrats will get an in-person absentee ballot site, and every ward that doesn't have 99% Democrats doesn't get an
Is that what happened here, though? Didn't Racine spread them
No,
all
Your Honor, but
over?
I think, but on the whole, as the analysis that's in the record concludes, on the whole, the sites did benefit one political party over
Based
the
on
others.
that analysis, which is so statistically questionable, we won't even go there. But my point is, you are correct that in a certain case, you might be able to prove what you're saying. But in this case, isn't it true that these sites were all over the city? So in theory, someone could, driving to work in some other place, vote.
Yes, but spreading the sites all throughout the city violates the other principle of the statute, that they must be as near as practicable to the clerk's office. And the as near as language has to be given meaning. It can't just be completely meaningless, as my colleague from Racine argued earlier, that the practicable language essentially means anything. That can't be. As near as has to mean something. Geography has to be the primary factor. First, you find a site that's as near as it can be to the clerk's office. Then you determine if it's practicable to have the absentee voting site there, or multiple sites. You go through the process as many times as you'd like.
Counsel, I'd like to return to a trifling interest. In response to the question of what trifling interest is there here, you responded that the trifling interest for standing is found in 5.06. I thought your answer would have been that the trifling interest for standing is in the review section of sub 8 because you are aggrieved. So why is it under 06.1, as I understood your response to be?
Your Honor, I think the interest is created by sub 1. The interest here in my client ensuring that his local election official is conforming the conduct to the law. The harm, the aggrievement to that interest comes from sub 8 when that complaint was dismissed, allowing for the appeal.
So where is your injury? Do you need an injury in your analysis? And if so, where do you focus your injury?
Well, I think the injury here is that is his harm that's caused when his complaint is dismissed, and because WEC has applied in our argument an improper interpretation of the law.
So it has nothing to do with the MVUs. His harm isn't created by the MVUs, or his harm isn't created by the fact that there are these multiple voting sites that are outside of the ward. You're saying that he is aggrieved, that he is harmed because WEC ruled against him?
So his injury is to first get before WEC. The interest that's harmed that he filed his complaint based on was the illegal use of the mobile election unit, which I'd like to get to in a minute. But the harm to bring the appeal was that he was aggrieved when his complaint was dismissed, and that's what the statute requires. And again, that's what the Court of Appeals found in Hess.
Just to follow up on this partisan advantage, political party advantage thing, if you were writing a holding in this case, as we might do if we address this question, a clerk places these alternate sites for partisan advantage when they, what? Fill in the blank for us.
Your Honor, my red light's on. May I answer the question?
Please do. It's kind of been open today.
So, Your Honor, I'm sorry. I think we would ask this court to reverse WEC's decision and to provide with the partisan advantage when the location that's selected affords an advantage to a political party, comparing that location to the clerk's office. I think that's the...
Okay, so the judicial sort of construction, the test you're asking us to adopt, because we've got some vague language, we've got to make sense of it, you need some sort of way to evaluate it.
Yeah.
The test is that you're asking us to adopt that this language means, and is best read as, and should be evaluated as, for us and for executive branch officials who have to deal with this, is they need to look at the ward-specific data, and it needs to be either in the same ward or equivalent in order to not run afoul of this provision.
Yes, Your Honor, but again, Brown's reading of the statute is the only one that accords meaning to all words in the statute and actually makes it quite easy on the clerk. The clerk doesn't have to engage in that ward-level data. If they just locate the alternate sites in the same ward that the clerk's office is, that would be as near as practicable, and it wouldn't afford an advantage to a political party, and it would make life easy. Thank you.
Is it possible to hear his best argument on mobile vans and why they're not?
I think that was a question. Can you make your
Yes,
best
thank
argument? Oh, well, you-
Yes, Your Honor. I would be happy to, and thank you for the opportunity.
Best means one.
The use of the van is unlawful, and it's unlawful for three reasons. First, the text and context of the statute makes clear that only fixed physical buildings are intended to be used as sites. Second, it's impossible to square the use of the van with the requirements under the statute for storing ballots and chain of custody requirements. And third, relatedly, there's no way to maintain a consistent definition of site across all the relevant absentee voting statutes while also allowing the use of a van. If you only want my best argument, I guess I'll give you the statutory text. 5.25 establishes that polling places shall be public buildings unless the use of a public building for this purpose is impracticable or the use of non-public building better serves the needs of the electorate. That is not limited to polling places on election day.
But that's a polling place. Can I ask another question?
That's what I was going to follow up.
Yeah, can we just let him try to finish what he wanted to say, and you are next up to ask him.
Thank you, Chief.
And you don't necessarily have to talk really fast.
But
Understood,
you can
Your
talk
Honor.
slower than Justice Hagedorn.
That's quite a standard.
Your Honor, perhaps anticipating your question, a polling place is simply defined under the statute as the actual location wherein the elector's vote is cast. And I think that definition of polling place actually supports the idea that a polling place has to be in a building. It says wherein, not where at or at which. It's wherein. Wherein implies a building. You're in a building.
Right, so this is my pushback
Yes, sir.
on that. Are you done? Sorry. That's polling place. That's where I go on the day of the election to vote. This case is about the alternate voting sites where I go to vote before the election as an alternate site that is not a 5.25 site. And one says building, and one doesn't have building in it. It just says site. So I'm having a hard time applying the 525 definition onto the definition in Chapter 6.
Yeah, Your Honor, and I would argue that all in-person absentee sites are also polling locations. They meet that definition under the statute as a place where votes are cast. But I think the other textual clues also imply or also make clear beyond just the 5.25. For example, under 6.88, when a ballot arrives at either the office of the municipal clerk or an alternate site, if applicable, and here they were applicable, the ballot has to be sealed in an envelope. Instructions get printed on the envelope that say it shall not be open until it's counted. I'm paraphrasing, obviously. And once sealed in the envelope, the statute requires that the clerk, quote, shall keep the ballot in the clerk's office or at the alternate site, if applicable, until delivered to the individuals who will count them. It's impossible to square the use of the mobile van with that statutory requirement because they're not keeping the ballots in the van. It's undisputed. The clerk has admitted that she brought them into her office to store them, right? You don't store the ballots in the van. And that gets to the other problems with it, that, for example, the sites that were actually noticed weren't even the sites that were used. The site noticed a church, noticed the beach. Voting didn't occur in the church or at the beach. It occurred in the van, which was parked nearby. The statute contemplates, you notice buildings that you would go to. I think 7.41 1 and 2 require that within an alternate site, observation is allowed within 3 to 8 feet. Certainly within a van, 3 to 8 feet might be difficult to be there. I think that certainly implies that a building would. I think all of these textual clues viewed together certainly indicate that the legislature required that a public building be used for alternate in-person absentee locations.
Thank you. Thanks for answering all my questions. Thanks, Chief.
All right,
Thank you.